back to Indigenous Voice. My name is Adam Olsen. I'm your host this evening. And we had such an amazing conversation in the last episode with Roshan, Danesh, and Doug White about consent, consultation, engagement, Aboriginal consent. We invited them back for this episode. We're going to start to explore the issues a little bit deeper. Good evening, gentlemen.
Good evening.
Maybe you can take just a minute to once again introduce yourself to the audience in case they didn't see the last episode.
Great. Thanks, Adam, and really happy to be here again and with yourself and Doug. I've been doing this, the work for First Nations across British Columbia and Canada for about 15 years now. And I really came to that work building on work I'd done internationally for the United Nations and others on complex conflicts and interethnic conflicts and how to build unity in those situations. And really look forward to another good discussion tonight.
Awesome.
Thanks, Adam, for the invitation back. My name is Doug White. My co-Salish name is Kwulasultun. Nuu-chah-nulth name is Tliishin. I'm a counselor at the Stanemo First Nation, acting chief there right now, but also the director of the Center for Pre-Confederation Treaties and Reconciliation at Vancouver Island University. I'm a member of the BC Aboriginal Justice Council. I'm the president of the Native Court Workers and Counselling Association of BC, and also a lawyer. In all of my adult life, I've been working on these issues. So happy to be back to talk about this important stuff.
Excellent. You know, these are probably some of the most important conversations that we can be having in our country right now. We've just come out of a very long discussion in our country about through the Truth and Reconciliation Commission about reconciliation, which I'm hoping that we can focus our conversation about this evening, because there's lots of big terms here. You know, we talk about consent, talk about the duty to consult, and today we're going to be talking about reconciliation. But just before we move into reconciliation, perhaps, Doug, maybe you can pick up on it and just give a minute definition of what those other terms are to maybe lay the groundwork. Maybe consultation, and Roshan, you can pick up on consent. Or
yeah, sure. This is all about how do First Nations and the Crown interact with respect to decisions across Aboriginal territories and spaces in British Columbia and across the country. For a very long period of time, up until the Haida Nation decision a decade ago in 2004, the Crown believed it could make any decision it liked. It was the landowner, it had the jurisdiction, and it was unconstrained in its decision making. The Haida Nation decision changed that and made clear that the Crown is not unconstrained in its decision making, that it cannot run roughshod over Aboriginal rights and Aboriginal title, that in the context where rights have yet to be firmly defined either by treaty or by a court decision, that in that circumstance the Crown owes to the Indigenous peoples a duty to consult and accommodate. So that there's still a very firm idea that the Crown is still ultimately the only decision maker, but as part of their decision-making process they have to go and engage with Indigenous peoples, try and grapple with the issues that are raised by the potential decision, try to find ways to minimize the impact, and try to find ways to accommodate the Aboriginal interests that are at issue. And from consultation, we've been, it's fundamentally changed the relationship between Crown and First Nations. We never saw each other before, effectively. We were in a period of total denial. And now, over the past decade, there's been lots of intensive engagement. On the First Nations side, there's been concern about how it's been far too much focused on the process end of discussions as opposed to dealing with the real substance of the issues that are raised. And I think now with the Tsilhqot'in Nation decision from a couple of years ago, we're now shifting into a fundamentally different framework where there's two decision makers. And maybe Roshan, you want to talk about consent?
Yeah, I mean, just to pick up on Doug's point, I mean, we are at that critical moment of transition. You know, the whole focus on consultation over a few decades was really about building to this moment in time where we really grapple with the fact that we never, as a society, as a country, reconciled between Indigenous sovereignty and Indigenous nations and their pre-existence and their orders and their laws, and the Crown who came in and assumed that jurisdiction. and tried to assume those roles. And so when we talk about a consent relationship, the term consent appears 14 times in the Chilcotin decision as the standard to be followed. It's repeated in numerous articles of the United Nations Declaration on the Rights of Indigenous Peoples, the standard of free, prior, informed consent. It is all about how do we structure the proper relationships between Indigenous and non-Indigenous decision makers. And that's the work of this moment in history. That's this moment in time, what we're all grappling with.
If I can just add, it represents a fundamental rupture with the existing status quo because of the shift from a single Crown decision maker. The need for consent becomes a way of dealing with the reality that there isn't just a Crown that has authority. It's now also a recognition of the court that as part of the Aboriginal title relationship with parts of their territory, Aboriginal peoples have real decision-making power. And it's a recognition that that Aboriginal voice has to mean something, and the only way for the two decision makers to function together in a coherent, clear, respectful way that's premised on the idea of reconciliation and respect is through the paradigm of consent. So a new way of being together entirely from the past.
Well, but has consent just, like, is this a new idea, or has it been something that has been sort of threaded through all of the court decisions in the past? You know, you talk about this denial. You know, this country, our province has been in denial, and a lot of the reaction to this conversation is consent is a veto, et cetera, which we just canvassed in the last session where we were talking. Maybe just speak to a little bit. This isn't consent is not a new phenomenon in the discussion. It's really been there the whole time, has it not?
Yeah, I can speak to in the very early part of the modern era of Canadian Aboriginal law, going back to White and Bob, there was a different model that was articulated, one where the treaty relationship that was premised on the idea of consent, that we need a consensual relationship between the Crown and between Indigenous peoples here on Vancouver Island, one of real respect and recognition, non-interference, was very much premised on the idea of consent. And it actually was such that the way it's been interpreted over the last half century is that the Douglas Treaty rights are of such a special relationship with the Crown, the federal Crown, that the provincial government can't interfere with them. So the provincial jurisdiction is constrained and limited by the reality of the Douglas Treaty rights. And then, but all of that effectively being powerfully denied led us up to that point in time in the Haida Nation decision where consultation became the discussion. Embedded, there's been different ideas of consent have been stated in the law for a very long period of time, going back to the Delgamuukw decision in '97, talked about in the Haida Nation decision that in certain circumstances consent would be the standard that's required.
Right.
And now certainly, it's a basic old idea that stood at the very beginning of the relationship when it was premised on a nation-to-nation idea of respect and recognition. But that we're now just starting to, it's coming into sharp focus.
Yeah,
That's really important.
Yeah, and just to say it another way, if you ask yourself the question, why do we contemplate getting into treaties, for example? Why in the 1800s did we think treaties were required? It was because there was some notion in the common law and in all of these traditions that kind of relationship, that consent type of relationship had to exist. And so it's at the very root. And we really need to be careful, and we'll get into this more as we go on with language, because, you mentioned it quickly in passing about consent and veto. They're different things, and they're different concepts. And when we conflate them these days, it's usually done out of political expediency, fear-mongering, raising the specter, reinforcing stereotypes and racist stereotypes about certain of these issues. And we really have to be careful about that. When we use the word consent, we talk about the proper types of relationships we're to be in. When we use language of veto, it is about authority, it is about power, it is about trumping one another. It's the wrong dialogue, the wrong nature, and they operate differently as well. So, we really need to, it's good you wanted to delve into language tonight around reconciliation. It's really important we dig into what these terms really mean.
Yeah, so I was on the, speaking to the ministerial panel for Kinder Morgan, which I'm assuming there will be a decision coming out fairly shortly, but one of the panel members, the ministerial panel that came through Victoria, must be a couple of months ago now, talked about, I think the quote was, reconciliation. What does it even mean, right? And it's like, oh, that's a diversion from us actually having a discussion about it, right? We throw our hands in the air. So we have gone through a long, drawn-out process and a really good one to talk about through the Truth and Reconciliation Commission about residential schools, and really sort of Canada was introduced in a deep way for the first time about the history that has affected many of our families in residential schools. So reconciliation is a journey that Canada has started to walk down. British Columbia. So let's talk about reconciliation. And I hope there's a perception that reconciliation is something that the government does. I think that we're going to, it's going to be a little bit more complex than that. But let's start with a definition. Roshan, maybe you can start. What does reconciliation mean?
So there's many lenses we can bring to it, and it derives from many places. But let's just start with the fact that it is the term throughout all of that jurisprudence that Doug talked about, that the Supreme Court of Canada keeps coming back to, this term reconciliation. Mm-hmm. They say, for example, that the constitutional provision that a lot of our discussion is about, Section 35, the very purpose of it is to advance and effect reconciliation between Indigenous and non-Indigenous peoples. Now, I'm a lawyer. I teach law. Doug's a lawyer. We've both worked for decades. Let's just assume that they use their words with meaning, with conviction, that they actually say what they mean. Well, the term reconciliation, if you look into what it means, has many interesting dimensions to it. It is a term that at once speaks to dealing with the past, to dealing with what has been wrong and healing it and effecting justice in relation to it. It is also a term that speaks to a future state, right? It speaks to the type of interconnected relationship that we have to build with each other. It's also a term, if you look into how it's defined, and it's used in different societies around the world. South Africa, everyone points to about their work around reconciliation. It speaks to a structural level, like our institutions and our structures of government. How do those reflect the types of relationship that we want to see that deals with past injustice and creates future progressive relations? It talks about the types of processes and policies that we put in place, and it talks to the very fabric of our economy and society and how people relate. So the first thing to understand in using this term, the court is not talking about some mechanistic, legalistic approach. They're not talking about merely an exchange in the economy. They're not talking about just sort of social conditions changing. The word is chosen because it's an integrative, comprehensive, encompassing terms. It speaks to where we've been, where we are now, and where we're going, and all dimensions of our existence and relationships with each other. So that's just a first starting place. I mean, I'll let Doug jump in, and then I may jump back in on different ways of thinking about what reconciliation means.
It includes all of us. Doug, do you have any
It's
thoughts
been
on
there. I think about reconciliation, and we're most the way that it's being talked about a lot these days is in response to the Truth and Reconciliation Commission, but there's been multiple different streams of reconciliation that have been underway for differing periods of time. In basically over the past half century, we've had the development of the modern era of Canadian Aboriginal law, which, as Roshan said, is the Supreme Court itself directly states that this whole body of law exists for the very purpose of reconciliation. That is its animating purpose. That is what the overarching goal of this body of law coming into being is all about. And then we've also had important political streams of the relationship of reconciliation, starting with the early treaty process, the treaty negotiations in British Columbia that led to the pre-Confederation treaties based on the premise of nation-to-nation respect, recognition. More recently, we've had the things like the Section 35 of the Constitution, a very powerful political statement, the highest and most authoritative voice of the country speaking and saying that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And there was intended constitutional conferences that followed up from 1982 were intended to give fuller meaning to that. They were not successful. That's part of the reason why there's been so much litigation, because there hasn't been political clarity and political will to bring proper answers and to build that reconciliation on the political path. More recently, we've had also the economic stream of reconciliation, partially driven by the Haida Nation decision that brought First Nations importantly into the economy in a not a wholesome way, but at least shifting from where we were before. And now on the social side, our country's just gone through a very important process through the Truth and Reconciliation Commission, where some of the most personal harms of the colonial experience were brought to light. In my family, your family, we know that for many years, and for many generations, our people have been suffering from the experience of being in residential school, what happened there. And it's a very personal, very painful episodes that while the school shut down a long time ago now, or not that long ago, but a number of years back, that the harm and the damage continues in the present, and is an intergenerational reality. But the work that was done was driven by people seeking to make the people that inflicted harm on them accountable in a criminal context. The Plint litigation from the Alberni Residential School was one of the first major bits of litigation that led to other litigation emerging across the country, ultimately class action suits that led to the big settlement agreement between Canada, the churches, and Indigenous peoples, that led to the apology of the federal government, and ultimately the establishment of the Truth and Reconciliation Commission. So this really has become an important narrative. The approach that was taken by the Truth and Reconciliation Commission was not, it shifted out of the criminal mode of dealing with those past harms into much more of a future-oriented approach about reconciliation and justice, about how they very specifically sought to engage with the Canadian public in a very direct and very real way. They had very numerous different national engagement sessions across the country, where the very purpose was to raise awareness and understanding of Canadians about what had happened in the past, but to work together. This notion that we need to do this work together. I think it's important for the country to realize that a people can't inflict this kind of harm on another people. It's been described as cultural genocide by now Senator Sinclair and by the Chief Justice, Beverly McLaughlin of the Supreme Court of Canada. They both used the phrase, what this residential school system amounted to was cultural genocide. That's a pretty strong language. That's a pretty serious recognition of what happened. And so dealing with that and grappling with that becomes, when that kind of harm is done, it harms the country as a whole.
Yes.
And so there's work for all of us to do together in response to the reconciliation. And we have to be, when we're dealing with this incredibly powerful report that the Truth and Reconciliation Commission issued, 94 calls to action, that we have to understand that the way that we need to grapple with it can't just be limited from the lens of the residential school issues and experience, but take into account the legal pathways of reconciliation, political, economic, social, all together, and with Canadians being at the driving force of creating together a different reality for all of us.
I just want to touch on something that you said at the beginning of your answer, because there's this, you explained the Chilcotin decision as being a rupture in the Canadian legal framework, or the Canadian legal justice system. I view the residential school, I feel the residential school was a breaking, it was breaking people, and you're absolutely right. Every single one of us that grew up on a reserve, that lived on a reserve, that have got an Indigenous family, still feel the effects today of that. Reconciliation is going to be a healing process as well. Maybe, Roshan, you can pick up and talk a little bit about the social justice side of it and the healing that reconciliation can bring.
Well, I mean, few aspects jumping off what Doug just said. First, connecting to what you said and his use of the term cultural genocide. The characteristics of cultural genocide which is about eradicating the connection to identity and who you are, is that states that perpetrate that always target children, right? It's always about targeting the transmission of knowledge and making it a very high cost to remain connected to who one truly is, right? And the reason I wanted to, emphasize what Doug said is that we are still, though residential schools may have recently been, behind us, and we still have the intergenerational trauma of it, we still have a severe crisis about the connectivity and well-being of Indigenous children. And so that the pattern of the harm that was intentionally being perpetrated through the residential schools may well still be carrying forward into the future, just to show how great the challenge is that we all bear. Now, that connects then to this, where you started and where Doug was at about what reconciliation is. It's important to also recognize that there's two interconnected strands which reconciliation is intended to overcome. And these strands are the two policies that are really at the founding of Canada. This country could not have been founded and would not have been founded but for two pernicious policies at its core. One was the assimilation policy, the policy that these distinct Indigenous peoples needed to be eradicated and assimilated into the greater European politic. That's the social, cultural side. That's the side that the Truth and Reconciliation Commission tackles most directly, because the residential schools were at the core of that. But there was another policy that we have to overcome that was also core, which was the denial policy, which is the denial of the Indigenous governments and their relationships to the land and their rights and sovereignty over the land. The notion that this was an empty country when Europeans showed up to it. Terra nullius, the doctrine of discovery, these notions that have to be rooted. That denial policy, right? While the assimilation policy we're publicly grappling with, right, in various ways, in the ways Doug described, the Truth and Reconciliation, the denial policy, which is when we think about Aboriginal title and rights and the rupture Chilcotin represented, that is still very alive and with us. Not that the effects of the assimilation policy aren't alive and with us, but the denial policy is still entrenched in government policy. It is still at the core. There is not one statute of the federal or provincial government that was drafted with contemplating that Aboriginal people have rights, acknowledging or recognizing Aboriginal people have rights in this country. There is not one. They all are still premised on the assumption that the Crown has complete control, authority, sovereignty over the land base of the country as a whole. So this is why there's a intimate connection between what we talk about recognition and reconciliation. I don't know about you, but I have never entered a healthy relationship with someone while denying their very existence at the same time. Doesn't really work. I tried it when I was 18 a couple times, wasn't too successful. Right? But that's what we're trying to do. We keep trying to reconcile.
Yeah.
But we're denying. We don't recognize Indigenous governments, their connection to the land, the existence of their title and rights. When Doug says it's a rupture, it's because the court finally said, enough's enough. Right. Enough's enough. Title exists. Here's the map. It's real. It's not just some abstract concept. We gave you decades. We hid from issuing a decision, an order that said this. You didn't get on with it.
Right.
So we're making it so painful you'll have to get on with it now. So that recognition is a prerequisite to real reconciliation. They go hand in hand.
Which is moving past that policy of denial, and
Exactly.
perhaps the grand denial that this denial is also a part of why so many Aboriginal kids, Indigenous kids, are still in government care, and why the government care is still, failing to a great extent, because the residential schools may be done, but so many of our kids are still in government care. So it's connected back to the denial, and to recognition. I know that my sister, who's on a council, First Nations council, that is the thing that she continually mentions is recognition. My father, who I mentioned before, went through the Canadian court system right to the Supreme Court. Wants that decision to be acknowledged, right? And it's awful to move through life not feeling recognized or acknowledged, yet having everybody around talking about you and talking about your rights or your advantages that being advantaged. So to that, I mean, let's pick up on the BC treaty process, because I think to a certain extent there's a part of this which needs to be pulled out, and that is that as part of that discussion, if you want to enter into the BC treaty process, then you got to start from scratch. You got to give up your rights, and I think we touched on it the last time. But maybe, Doug, you can pick up on the BC treaty process and how that fits into this discussion of reconciliation.
Well, I would start with the intent and the purpose of the treaty process. When it was created, it was intended to address the outstanding Indian land question that had been at the core of Aboriginal Crown relations in British Columbia from the very beginning. That was the central animating question, political, legal question of this part of the world for a very long period of time. Every major Aboriginal political organization in the province was built around answering the Indian land question and addressing those issues that it raises. And so when we went through the Calder litigation. The Calder litigation prompted Canada to shift in some way away from the white paper that Trudeau and Chrétien had put forward.
Poorly named white paper.
The poorly named white paper.
Yeah.
That was conceived by them to reflect and to talk about a country that they wanted to create that didn't include Aboriginal difference, that didn't include Aboriginal rights. How can we conceive of a country where people are different, where some people have different rights? Aren't we all just the same? And so there was a very clear notion that Trudeau was out here in Vancouver in that time period, and he talked about treaty rights and Aboriginal rights as historical might-have-beens that don't have a role in this country. Then the Calder decision came along, the first sort of Aboriginal title bombshell in Crown First Nations relations in 1973. And to his credit, they shifted. He said, well, I was wrong. I was wrong about that. Aboriginal rights obviously do matter. Aboriginal title matters. And so they created the comprehensive claims policy to address the idea that Aboriginal peoples have a special relationship with their territories, that they have, there's something about the fact of their decision making about themselves and their territories that's important. And we need to be able to sit down again and start to figure out those issues in a new way. Now, in part, there was a big resistance from the provincial government. So the Nisga'a started to negotiate with the federal government alone. They negotiated from 1973 into the early 90s only with the federal government because the provincial government refused to be engaged. They said, well, if this is an issue, it's a federal issue, it's not a provincial issue. This is federal business, not provincial business. They're responsible, not us. And so if you want to go and sit down and negotiate with the Nisga'a people, you go right ahead and do that. But we're not going to participate. And so the people saying they're not going to participate are the ones that claim ownership over the totality of the Nisga'a people's territory. So it makes it a difficult negotiation. And so as we got through into the early 90s, we go through the Oka crisis, and there's other things that are happening that prompt another shift in relations and a realization that actually BC does need to participate. They're going to be a part of this, and we'll set up a new tripartite process. So the intent was to deal with the substance, that subject matter of Aboriginal title. I remember I was called as a witness at the very beginning of the BC treaty process at a ceremony in Squamish with the Prime Minister, the Premier, and Aboriginal leadership. I remember Chief Joe Mathias, the late chief from Squamish, who was an important leader that helped to bring this whole approach into being, standing there and saying very clearly, now is the time to leave behind the idea of extinguishment of our rights. Now is the time for us to once and for all have the Crown recognize the importance of those rights, the inherency of them, and that Aboriginal title will now be recognized. Now, that was in 1992. Of course, what happened, the Crown showed up with a very different disposition. Notwithstanding that they said they wanted to deal with Aboriginal title and this was the space, they came in a mode and with a mandate that very much reflected the patterns of denial and assimilation that Roshan talked about. And effectively, there was a very, very little progress made because of the fact that First Nations showed up thinking we were going to be dealing with certain issues, and the Crown showed up and said, oh, well, no, we're not doing that at all. Right. If you want to effectively extinguish your title and put it aside, set it aside, and take in its place little bits of fee simple land, then we can talk about that. But we're not here to talk about implementing Aboriginal title. And so, of course, for most of the First Nations in the province, the ones that thought that this might be a process, for the majority of them, it's not a plausible pathway. So it's been a very frustrating, long process that has not been productive of the work that we thought it would be, and has not been resulting in the kinds of agreements across the province that was imagined in the beginning. And so, it's been very disappointing. Now, it's like there's the Chilcotin decision changes all of that. It has to. And I want to, if I can tell a little story about this, I think it would be useful for the people to hear this. Why it's important to understand why the Supreme Court of Canada made the decision it did. Roshan alluded to this a little bit, but you're asking about what's wrong with the treaty process, or why isn't the treaty process doing this work? And I want to tell a story about the Hulkaminam Treaty Group, a group that had been committed for many years to seeking to negotiate a treaty with Canada. But they went to the Inter-American Commission on Human Rights a number of years ago now in Washington, D.C., and they said to that body, that international body, we want you to say something about the fact that we in Canada, as Aboriginal peoples, cannot have, there is no way for us to have our Aboriginal title demarcated and recognized by the Crown. Mm. And we believe that fact, that reality, that denial of our Aboriginal title infringes on the human rights of us as Aboriginal peoples. And we want you to say something about that fact. Mm-hmm. Canada pushed back very aggressively on a procedural issue. As a matter of international law, you can't be in this forum because you have not exhausted your domestic remedies. Canada argued to silence the voice of the Hulkaminam peoples in the international forum. They said that the Hulkaminam could have gone to court to have their title recognized, or they could be in the treaty process. That prompted both the Hulkaminam Treaty Group itself, but dozens of First Nations and First Nations organizations across the country to send in amicus curiae briefs or friendly briefs to the Inter-American Commission to tell the story of the history of litigation in the country, and also the story of what the BC treaty process has become. Right. And the court agreed in a very embarrassing decision for Canada. The Inter-American Commission agreed that there are no effective domestic remedies in Canada for Indigenous peoples to have their title recognized and demarcated at that time period. And they said, there's been 4 decades of litigation, tens of millions of dollars spent, and not one decision from the courts. And they said the treaty process, for its part, we understand that it's not about implementing title at all. It's about setting it aside and taking fee simple in its place.
Is there any other examples in our country where people are asked to set aside their rights in order to then start a negotiation about rights? Like
no, I mean, this is, and I said it last time. I said, could you ever imagine a government going up to an individual Canadian and saying, if I give you this amount of money, or I give you this, right, can you just agree that your right of free speech is gone? I mean, it's unfathomable, right? It's an impossibility. No, we wouldn't even conceive of doing it, right? The only people in this country who are asked by the government, hey, why don't you give up all of those rights that are enshrined in the Constitution? Are Indigenous peoples in processes like the BC Treaty process, right? And that fact alone continues to show the entrenchment of the notions of denial that run so deep. And just to add a bit of, like, so the story Doug described, the treaty process has been in place for 25 years. It's cost $1 billion plus, probably. There's 4 treaties that have been completed out of it. I mean, depending, some nations are grouped together under one. The vast majority of nations aren't engaged in the process in any way at all any longer. And the distinction between Chilcotin, Chilcotin says Aboriginal title exists on a territorial basis over large tracts of land. The Crown says, how about we give you, 5% of your territory or 10? It's a gap it's a chasm in terms of how it fits together.
I want to finish the storyline, because what the courts were saying, the reason why they didn't make a decision over that period of time was because they were saying to politicians, please go and sit down and resolve these issues.
Reconcile.
The courts are ill-equipped to deal with the complexity of these issues. And in the late Justice Vickers' Chilcotin Nation trial-level decision, there's 20 paragraphs where he talks about reconciliation, the theme of reconciliation. Please go and embrace this idea and go and sit down and do this hard work together. Go and do that. And ultimately, there was no political will to do that. And the failure of the politicians and the political process, it effectively backed the Supreme Court of Canada into a corner, where the very integrity of the legal process in Canada was at issue. Where they couldn't continue, they couldn't spend another decade not making decisions about Aboriginal title. It's either justiciable or it isn't. And Aboriginal people should know. The courts, are you going to be a forum? Are you going to help to resolve these complex issues or not? You should probably tell us, because we don't want to spend another decade and another tens of millions of dollars in processes that are not productive of remedies for Aboriginal peoples. So it really emboldened the court to say, we have given politicians decades of time to reconcile. They've not shown up with the right political will, and so now we will make our decision that fundamentally undercuts and ruptures the status quo, and it will become an absolute necessity for Indigenous peoples and the Crown to sit down and start to resolve these issues.
And just jumping off that, the court doing that is also part of their way of signaling something about the meaning of reconciliation, because there's a fundamental divergence and tension between adversarialism and the courts and how they're structured and how I defined reconciliation at the beginning. They can't do that stuff, right? They can't help us and show us how to love one another in new ways as a society. They can't say restructure your patterns of community relations in this way and show how to relate in new ways. But what they can do is make it extremely painful if we're not doing that in a really diligent and meaningful way, and establish a framework, an infrastructure within which one would do that. When Doug talks about the BC Treaty process, 25 years, and the evolution of the law over 25 years, what happened is this, right? The law developed on a trajectory, and the BC Treaty process didn't maintain a connection to where the law had gone. So the framework that's now required under Section 35 isn't reflected in that process. So that's a moment in time we're in now under Chilcotin, where all of that and how we do it has to change. But reconciliation, to really do it, involves also, as Doug has talked about, all the different trends, getting out of the courts and doing the work in people's lives, in communities' lives, in the children's lives, between governments, between politicians, between communities next to each other in real ways. The court is trying to push it to the real work getting done.
I want to touch on a couple of things, because the money, the billions of dollars, when I hear hundreds of millions of dollars, tens of millions of dollars, $1 billion, it freaks me out, because that often gets used, right? That gets used as a tool then to say, look at how much money we've spent on this issue, and look at how much little traction there's been. And when you put $1 billion and then you throw 4 treaties out, that freaks me out even more. It makes me really uncomfortable. It makes Canadians and British Columbians very uncomfortable. But I want to talk a little bit about that money, but sticking with the Treaty Commission here for a minute, because I don't know another process where you have this tripartite discussion, the 3 parties, and only one party is accruing debt. And so I remember when the provincial government decided that they weren't going to appoint Mr. Abbott as the new treaty commissioner, and one of the reasons why was because how much money has been spent and how little traction has been made. And then the federal government came out shortly after that and said, so much money has been spent, and such little traction has been, so few treaties have been signed. But yet, all the time, the only group in this whole discussion that's been accruing debt and the pressure has been on the First Nations communities that are a part of that. The federal and provincial government just continue to tick along. And so the impression was left, look, First Nations are not moving quick enough to solve these, to sign these treaties. So maybe talk a little bit about the money and that side of it. Am I wrong in that First Nations are the only communities carrying a financial burden on this? I mean, clearly Canadian and provincial government are spending money on this, but there's no connection to the political party that's doing it, right? So
I think it's widely recognized as one of the fatal flaws of the design of the BC Treaty process is this notion that Aboriginal peoples would borrow money to negotiate with the Crown over Aboriginal title and self-government and these issues. The passage of time has made it almost an absurdity, where in some cases the loans that are owed by First Nations are surpassing the offers that are being made by the Crown in terms of resolving the relationship. And so it's become an intractable situation. Not only, one of my real concerns of Snanemo's participation in the treaty process over those years is just the opportunity cost of not getting real work done. That every year that people are sitting down in a process that does not have any potential for the communities, that can go anywhere productive, is a year that they are not spent dealing with violence against women, or dealing with the needs of the elders, the education of children. We could have been building schools, we could have been doing all kinds of things that are necessary in our communities. But we were sitting there in good faith in the belief that we were in a process that was going to go down a certain path that it did not. And so there's an enormous opportunity cost associated with the treaty process as well, I think, for everyone. This is time and effort and resources that could have been spent in far more meaningful and useful ways. And so to me, it's extremely troubling. And the debt itself has become an obstacle for First Nations to pull the plug because there is no existing mechanism to properly shut down a negotiation that is not going in the right way, that doesn't trigger the loans being called and all of these things. There's no, it's almost like nations have become trapped in a discussion that they can't get away from. And so I think sooner or later this is something that's going to have to be resolved. Like, we need an answer to that issue. We need to be able to clear the decks and come up with, in the post-Chilcotin reality, what is the proper discussion, what are the proper issues, what are the proper goals that we need to seek to collectively achieve, and how are we going to do it in an effective and timely manner. Because the treaty process model is nothing but a cautionary tale of what is a path not to go down.
So that treaty, the way it's set up with the debt being accrued by the First, it creates an anchor. So you can't, you actually, and as you said, there's no way out. So it really, it then becomes a negotiation that, well, it's not a negotiation. It's not a negotiation that you can feel like you can walk away. A negotiation, you should be able to feel like you can walk away from the table, is what I'm really trying to say. And if you don't feel like you can walk away from the table and you feel like a prisoner of that, then that becomes a big problem.
Yeah, we're sort of, at this moment in time, we're sort of trapped in some entrenched way of ways of doing things that are antithetical to where we want to go. We're trapped in this adversarial way of fighting through the courts, which we can get into the same high numbers that the Crown is spending, that First Nations are spending. You add up the number of court cases and the costs. If you had reinvested that in actually doing the substance of the work and building the relationship and investing in the kids and so forth, you would be so much further ahead. We're stuck in that place. We're stuck in processes that have as their core precepts things that aren't in line with the goals that are now there that have to be achieved. And this requires some hard, courageous choices to be made by First Nations about how to push forward in a new way. And we need real leadership from Crown governments about how to do it. And this is why, what's been so interesting when you talk about reconciliation and how it advances, and I think we talked a bit about this last time, there has been a growing sea change in public awareness about what these issues are all about. There's a public discourse that's now foregrounded, right? It's on the front pages, it's in people's attention, daily. Wasn't the case 5 years ago, wasn't the case 10 years ago. That should hopefully, while it brings out many strands of attitudes that have to be worked with, that should be a force of accelerating and pushing out of the broken patterns of trying to deal with these issues that haven't got us where we want to be. And that's critical. That can be a real changing factor in accelerating how we drive towards real change. Just to give you one example, just briefly, because it was in the news this week with Grand Chief Ed John's report about Indigenous child welfare and child protection. I don't really want to say much about the report, except the fact that it hits the theme that has been there known for decades now, that the only solution ultimately to the well-being of Indigenous children is to confirm and recognize that the jurisdiction over those children lies with the nations themselves. Mary Ellen said this, frequently. Mary Ellen Tupel, the recently, completed her term as the representative for children and youth. The federal government is increasingly say this, and I think the province as well is acknowledging that ultimately this is the only solution to that one arena. And then certainly the Truth and Reconciliation Commission, its first 5 calls to action are all about this issue. But again, that's been talked about for decades now. We've got to get down and do it.
And the federal government has recently made clear that we need to shift to a nation-to-nation approach. We're going to implement the United Nations Declaration of the Rights of Indigenous Peoples. Those two statements mean we need to be doing our work in a fundamentally different way. There is no incremental shift or change to a process or adjustment or minor adjustment. It's like, okay, down tool, we've had the wrong approach, and we need to figure out and work together to figure out what is the process going to be, how are we going to talk about these issues, what are we going to be seeking to achieve in a fundamentally new way. Because the existing approaches are not premised on the idea of nation to nation, and they do not reflect the principles of the United Nations Declaration of the Rights of Indigenous Peoples. They don't reflect the highest statement of Canadian law about Aboriginal title in the Tsilhqot'in Nation decision. They are inconsistent with those fundamental statements and directions, and we need to recognize that we're at a moment where we're at a defining moment where we have to do the hard work of building a new path together.
So is that language, nation to nation, then perhaps one of the first times that we are recognizing multiple decision makers, sovereigns?
It's certainly explicitly implied in it, sure, that is what it is. And it has many, and you'll see the dialogue becomes about no longer the discussion being about how do Indigenous peoples and Indigenous governments operate within Crown decision-making processes, like the consultation paradigm, which is, tell us what you think and we'll consider it in our decision-making process. The whole discussion becomes a discussion about between governments, between legal orders, and building what that in-between space looks like. How we interact, what structures we create together, the processes we have to ensure we come up with collaborative outcomes at the end, how we have common goals and who's doing what, our fiscal relationships, which is all about the between and not about the within. When Doug talks about moving out of, the Crown being the sole decision maker, we have to shift our dialogue to focusing on that space.
So the residential schools had dramatic impact on Indigenous people right across the country, but it also the relationship between the Crown and Indigenous peoples in our country has had a profound impact on Canadian society on a whole. And one of the things that when we start having these discussions, that the old reactions, the deeply entrenched feelings about Indigenous people in our country start to come out. I mean, newspapers have, and online news sources have stopped posting the comments and stopped allowing people just to anonymously comment, because some of the stuff that we could read there was just straight depressing to think that it's 2016 and we're still having this discussion. So I would like to move this discussion as we get towards the end of the interview here to have a discussion about how Canadians, British Columbians, everybody can, First Nations people, Indigenous people have got a lot of work to do to overcome that break, the brokenness. What about Canadian society? Because to a great extent, the reactions to these kind of discussions is a broken one as well. You have any ideas about it? Because the language that we're using here is we, and that includes everybody in our country. And reconciliation is an action not that the government takes or that Indigenous people take, but it's an action that everybody must take. Do you have any comments on that?
I think you raise a really important issue about the pathway of reconciliation and what are the components of it. How do people need to participate in it? This can't be a top-down process. I think we're at a moment where, sure, there's continues to be a lot of racism in the country, systemic racism, direct, explicit racism that can be communicated. I do think that we've come a long way from a generation ago. When we were in the treaty process, the very discussion in Snanemoch, where I'm from, the very discussion about these issues, that Aboriginal peoples might be given some consideration and some recognition, led to the single act of violence I'm aware of in the entire BC treaty process. When the provincial negotiator was briefing the city government in Nanaimo, and this is in like 2001 or 2, somewhere in there, so outraged was the city manager by this briefing that some lands inside the city might come back to Snaneimo, that the Snaneimo might have a say over their future, that he attacked the provincial negotiator. It was astonishing. And the very discussion in the community about Aboriginal rights and about we're negotiating the treaty, it generated a lot of racism in the community. We would hear anecdotally from community members, they would be, why are you guys talking about these things? My grandson's getting bullied in school. He's experiencing racism in the schools of Nanaimo because of the fact that you're talking about this stuff. And it was a pretty miserable thing to witness, that reality. I didn't like it at all in any way. But now, I was chief for 4 years at Snaneimo from 2009 or 10 until 2014. We got to a reconciliation agreement in 2013 with the province of British Columbia on a bilateral basis. And that day, that historic moment in the progression of the relationship between the Snaneimo and the Crown, the local newspaper in Nanaimo decided to publish a racist, ugly letter to the editor. Old 19th century ideas about who Aboriginal peoples have contributed nothing to the world. But the response then, now 10 years after the violent incident, the next day we had the mayor of Nanaimo, most of the council of Nanaimo, MLAs, MPs, half the crowd was non-Aboriginal. The national chief was there, leadership from across the province and island was there, protesting and denouncing that kind of expression of racist nonsense from the past. Mm-hmm. And so there's an arc of change that is clear. We're making we have a long way to go, but reconciliation is going to require that kind of a response from Canadians to stand up and to be a part of it, shaping a different
Very
reality.
briefly, I'm getting the wrap up.
All right, well, just two quick things, just to carry on your story about the incident in Nanaimo. And later that week, we held a public meeting for the public at a heart. 300 people show up to dialogue about how to deal with racism in the community. How often do you think that has happened or happens, right? That shows the trajectory as well. I would just end with like one or two statements. You know, Doug and I both work closely with Grand Chief Stuart Phillip, and he always uses the phrase that reconciliation is not for wimps, right? Just like in our own human relationships, it's hard work, and we all carry responsibilities and roles with it. The notion that this work, that any of us is absent being affected by it, being impacted by it, or has a positive role to play is a fanciful one. We all are, in our schools, our children, in our communities, in our healthcare system, in our education system, in all of these spaces and places that we try to build a society. The disproportionate sociocultural and other gaps between Indigenous and non-Indigenous peoples create real impacts, and we have to all play a role in dealing with those.
Thank you very much, Doug White, Roshan, Danesh. Thank you very much for coming back and joining us for another hour. This is an incredibly important conversation that we all need to have in Canada and in British Columbia. It's important that we have this discussion so that our children in the next generation are not inheriting the things that we've inherited, the issues that we've inherited. So please be open to the discussion, embrace the discussion, because we'll become a better community because of it. Thank you for watching Indigenous Voice, and we'll see you next time.